sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Dun, dun, dun. All right, good morning, Osceola.
Good morning, Judge.
All right, sorry about the delay. It's been a domino effect ever since I was doing crazy emergency warrants last night and early this morning, but we will finish it off with a bang today. So the first case we're going to call up is James Bartell.
Alicia Smith on behalf of the Public Defender's Office, Judge.
I'm sorry?
Alicia Smith on behalf of the Public Defender's Office.
Oh, yes. For the record. State for the record?
Ralph Lano III, Assistant State Attorney, Office of Monique Worrell.
Perfect. All right. Good morning, Mr. Bartell. You are here today for the on your initial appearance for battery. I have reviewed your charging affidavit. I do find there is probable cause, and you do not qualify for pretrial release, but I will set your bond. Is there anybody here on your behalf? No. So I will set your bond at $500. You are not to return to the scene. You are not to have any contact with the victim or any witnesses. Did I say $500?
If I may, Pat Hill on behalf of PTR. I did have contact with the mother of Mr. Bartell, who is the alleged victim, and she is requesting contact. She is his caregiver, and there's some issues that he requires medication for, and she's the one that monitors that medication.
All right, so then no hostile contact, and he may return. No hostile contact.
You say $500.
$500 bond, yes.
You can go back home.
May I call her?
No, they'll take care of it.
Okay.
Yes. All right, good luck to you, sir.
Excuse
A
me.
PD is appointed, yes, sir.
May you
Yes, ma'am.
repeat that?
Public defender is appointed.
Okay.
All right. The next case is Angela Beloyanis. All right. Good morning to you. You are here for the charges of possession or use of a drug paraphernalia, resisting officer without violence, possession of cocaine, and altering or destroying concealed remote recreational drugs.
Your Honor, the second charge is actually resisting with violence.
With violence. Sorry about that. What's the last one?
I'm not sure, Your Honor.
Altering or destroying or concealing.
I think it's tampering, Judge.
Tampering. Okay, that's better. Tampering evidence. All right. So I do find that there's probable cause for the listed enumerated offenses, and your bonds will be set as follows. As to count 1, it will be ROR. As to count 2, the bond will be 1,000. As to count 3, the bond will be 500. And as to count 4, the bond will be 100. Public defender is appointed to represent you.
Thank you, Judge.
Thank you. All right. Shane Brownfield.
He is coming from the back, Judge.
Thank you. morning, Mr. Bromfield. How are you doing today?
Good morning.
All right, so you currently out on pretrial release for resisting officer without violence and petty theft. I'm going to revoke your PTR because you're arrested for similar offense of petty theft. You'll have to see the division judge for a new bond on that 2022 MM874 case. On your new offense of petty theft, I'm setting your bond at $250, and I'm appointing a public defender to represent you. Good luck.
And that was 22 MM874 for the other case? That CTR was
Yes.
on?
Yes.
Thank you, Judge.
Revoke PTR, yes.
And this one stayed.
Yeah. All right, next person is Giovanni Burgos. All right, Mr. Burgos, welcome to Florida. You looks like you have a battery and a violation of domestic violence injunction from New York. And I find that there's probable cause. I'm appointing public defender to represent you. Setting your bond at $500 on each count. Is anybody here on your behalf? I see somebody moving forward. Maybe yes. No. No. Okay. So no contact. You already have a no contact order anyway. So no contact with the victim.
There's a no offensive order.
I'm sorry?
Contact. There's a no offensive order.
That's same.
And-
That's, in Florida, that's called a no contact order.
Yeah, same thing. Talk to your lawyer. No contact, okay? Good luck to you. Hope the defender's appointed to help you.
I didn't hear the bond amounts.
The bond amount's $500 each.
Thank you.
All right, Nicole Busby. Oh, I should have put this with all the other things. Oh, here they are. Okay. Nicole Busby. I'm going to make sure I get this right. There's a lot of cases here.
Yes, Judge, and I have a PC argument on one or two of the warrants.
Okay. I think I put them all together. Go ahead, counsel.
Yes, Judge, and looking at, I think it's the 22 CF 1290 and 1291, the offense dates are the exact same, and the warrants appear to be the exact same, so I would argue that there's not probable cause for one of them because they're duplicates of each other. So I would ask.
So just to make sure that the record is clear, can you list the ones that you believe are duplicates?
22 CF 1290 and 22 CF 1291.
1291, 1290. I see 1290. I see. This is 1291.
Yeah, and then the other one should be tore up. That's supposed to be?
It's supposed to be too.
Yes, this one should be. Right here.
This.
1290.
Okay, here. All right. 1290 and 1291. All right, proceed. So you believe that they're the same, although I don't have a
The warrants are
factual
the
basis.
exact same copies of each other, and they're both for petty theft, third offense. So
Okay, yes, they're different. All right, state.
Your Honor, I don't have the warrant in front of me. It was not sent over by the agency, but I can't stipulate to what the PD is saying. So without any knowledge other than what I have, it appears that they are two different offenses, but I can't add anything other than that.
All right, well, I do have the charging affidavits that were provided. I'll find PC for one and not for the other at this time. We have plenty of offenses to find PC for. There is also CF 22 596. So I'll appoint the public defender to represent the defendant, Ms. Busby. I'll find probable cause on 22 CF 1291. I'll find that it's duplicative. 12 CF 22 1290. Well, I guess I should find it in the opposite because it's the lowercase number. So 1290, I'll find that 1291 is duplicative. Set the bond for 1290 at 1,000. Then we have 22 CF 596. I find no reason to have this bond at 3,500 when it's similar to the other offense, so I'll also have this bond at 1,000 as well.
Thank you, ma'am.
So ROR on 1291, 1,000 on 1290, and 596.
Yes.
And Your Honor, she is also out of bond for petty theft. Osceola County Case 21 CF 3705.
All right, so that will be revoked. She'll see the division judge for that.
Do you have date of offense for that, Madam PTR?
Yes,
Said 21, 7.
it was 12/24/21.
Can you repeat the one she's out on bond for? The PTR?
Yes.
What's the case number?
Oh, 21 CF 3705.
And she was out on bond? Bond, right? Not
Bond. Was she out on bond or PTR?
She's out on bond.
Bond, okay.
So you revoked that and said,
Yes, revoking bond.
okay.
All right, that's done. All right. Next case is James Capers. All right, good morning, Mr. Capers. You're here today for your initial appearance on leaving the scene of an accident with injury, non-serious bodily injury, and leaving the scene of an accident with property damage. I'm appointing public defender to represent you. I find that there is probable cause, and I'm setting your bond as follows: $1,000 for count 1 and $100 for count 2. Good luck to you.
There are two cases, Judge. I was going to argue that there is no PC based off the four corners for the leaving the scene of the accident case. For the resisting on that case, I do say there's PC in that one.
Which one are you arguing that there's no PC for?
For the leaving the scenes, there are two police reports, because he has two cases. One is the resisting and the 2 counts of the leaving the scene.
Okay.
Nothing in the police report indicates, they say they responded to a traffic crash, but nothing in the police report for the leaving the scene identifies the person. They talk about the person who was injured in that one, but nothing identifies Mr. Capers in the 4 corners of the leaving the scene police report.
Okay, response?
Yes, Your Honor. Yes, Your Honor. In that one, I don't see the defendant's name mentioned at all, other than when he charges him. So could we get a 24-hour reset on this so I can contact the officer and push it over to tomorrow?
All right, counsel, do you want a 24-hour reset or do you want the bond? I just was going by the part that said that the suspect was found giving chase to the Osceola Sheriff's Office.
That was in the resisting police report. So that's what I was saying. In the 4 corners of the document itself, there was nothing on the leaving the scene that gave rise to him. In the resisting, I can agree that there's probable cause in the resisting police report, but there are 2 different reports written about 2 different officers.
Oh, I guess in mine they were stapled together, so that's why.
So yes, I would ask for the 24-hour reset, Judge.
Okay, all right, so 24-hour reset.
And then are you finding PC for the resisting, or are you just want to roll them and keep them both together?
I don't have a problem rolling them both together because he's not gonna be able to bond out on them. So we can just roll them both together.
Okay.
So do not send this bond for $1,000?
No. Yeah, just leave it. So you're gonna be reset for tomorrow.
Okay.
Is that what your client wants?
Well, I know that one of the police reports had bonds listed, so I don't know if you were staying the bonds and resetting for PC.
I was gonna reduce it. So if he could bond out, but if you wanna reset it for tomorrow.
I mean, I guess if the court's inclined to reduce it, I had bond amounts listed. That's why I was saying when you were saying staying in at 0. Sorry.
No, I said I was gonna reduce the count 1 to, what's it, 1,000, and then count 2 to 100. And then the resisting, I hadn't addressed it yet, but
Okay, gotcha.
the resisting, we could be 100 as well.
Okay.
I could set those bonds, and if you want to reset it for tomorrow,
Yes, Judge. If we could set the bonds and then reset for tomorrow as the PC.
okay. So lower the bonds and just reset for tomorrow for PC argument.
And then if he bonds, he bonds. If not, then we can address it.
All right.
Thank you, Judge. PD appointed us to both.
PD's appointed.
You can have a seat.
Let's see what happens. All right, next case is Treshawn Cotton, or
And Judge,
Trayshawn.
I have a probable cause argument that's gonna go to this, Mr. Duggar, Mr. Mouche, and Mr. Turner.
All right. Well, they're all mixed in, but guess let's go ahead and pull all those together.
The
Duggar's
argument's gonna
here.
be the exact same as all of the reports are the same.
Yes. Say the names again. I remember reading all of them, but
Cotton, Duggar, Mouche, and Turner.
I'm appointing both defendant to represent all, even though I know that'll be a conflict soon. Shay. We're calling out of sequence. Just looking for Turner. Turner. Carry the Kimarian Turner? Yeah, okay. All right, let me proceed.
Yes, Judge, they were all arrested for the same offense, armed burglary with a firearm and petty theft. There's nothing in any of the reports that identifies them, number one. It just says 4 black males. Number 2, there's nothing to indicate that they were actually armed, that specifically they were armed with a firearm. And then number 3, in terms of the petty theft, they indicated that items were taken. Nothing indicates the value of the items, so I would argue that there's no probable cause to identify any of the 4. But then even if you say that, okay, they were arrested, they were identified, nothing to indicate that they were armed, there was a firearm, or the value of the item. So I would argue there's no PC for any of the counts.
All right, response?
Yes, Your Honor. In the report, the officer mentions that he was conducting surveillance, and while he does not name the suspects by name, he had continuous contact when he observed them go into the vehicle and take the property, and then immediately followed them and arrested all 4 of them in the same vehicle. And while he doesn't mention the name in the report, the name of the people arrested is at the top of the report, so I think that would apply as to the specific naming. Although he did not mention the things that were taken, and I also don't see mention of a firearm. So if the court is disinclined to find PC on that, I would again ask for a 24-hour reset to contact the officer to supplement his report.
All right. This is a severe case. There was also, I guess there was a chase that was cross-county. I do agree that the males do need to be identified at some point, and there's insufficient facts, but I will grant 24 hours for you to get more information. We reset to tomorrow.
And that's for all 4, Judge?
All 4.
Thank you, Your Honor.
Yeah.
You can have a seat. So just for the record, that's Treshawn Carter's reset for 24 hours, Reginald Duggar's reset 24 hours, Reginald Mouche, and Kamarion Turner.
Yes, ma'am.
Perfect, thank you, Judge.
Counsel. All right, the next case is going to be John Doe. Should we have a name here? Why do I think we have a name here somewhere?
That's Carlos Kendall, and he needs the interpreter.
Are we sure? Venezuela, maybe. Are we got 2? All right, do we call it?
Yes.
You
All
said
right.
we call it or no?
Yeah, let's set that to the next,
He's gonna-
so
he's
to
gonna
the
do
end.
interpreters at the end.
All right, Sean Gaines.
Oh, there's a victim?
I'm sorry? Oh, he has a victim, okay. All right, let's let the person in. Oh, I pressed him? I wasn't pressing that yet yesterday.
So you know what a button is over here?
If I press the button, I think everybody would come for help.
No, I think the other one, the gray box. The gray box. See the gray box?
She did.
So, when she go out, don't let it slam and it won't lock.
Okay. Whew. I'm dizzy doing that. All right. All right. So first of all, you are Mr. Gaines. You're out on PTR. but it was for fleeing and eluding. It's not a similar offense, so I'm gonna take no action on your PTR case. Now you have a battery, touch or strike, and resisting officer without violence. And we have somebody here on your behalf. Your name, please, for the record?
My name is Helen Russell.
Oh, you're gonna have to speak up.
Helen Russell.
All right, Ms. Russell. We're here now to assess whether we're gonna grant bond on Mr. Gaines' case. Do you have anything you want the court to consider?
Yes, I want them to consider the evidence. Police report, I never told them that he physically hit me.
All right, are you in fear of Mr. Gaines?
No.
All right, do you want him to return back to your address? Do you guys live together?
Yes.
All right, do you want him to return back to your house?
I told him under one condition, because he takes pills. He takes pills. And I told him if he's going to continue to take pills, no. Because that's why it all started, because he was under the influence and he wanted to take the keys to drive. I was trying to prevent him from driving a car. So I was taking the keys from him.
So this is not prescribed medication?
Correct.
Okay. All right. Any questions from the state?
Very briefly, Your Honor. Have any incidents like this happened in the past? Incidents of domestic violence?
No. Between me and him? No.
Okay. If something was to occur in the future, do you promise to contact law enforcement, call 911?
Most definitely.
And are you in fear? You're not in fear of the defendant?
No, I let the officer know that.
Okay. I have no further questions, Your Honor.
And I have to say one more thing too, ma'am.
I'm sorry, what did you say?
When they said that he resisted arrest, they never told him that he was under arrest. They told him that they wanted to speak to him, and he refused to speak to them. That was his choice, because they gave him a choice.
All right, well, don't worry. That'll be taken care of in court.
Okay.
All right. So, Mr. Gaines, you heard your girlfriend or?
I'm his mother.
Mother? Oh.
Yeah.
You look young, girl.
Yes, ma'am.
Okay. You got a pretty mama. All right, so you heard your mom. She said that you can come back home, but she doesn't want you taking pills. You understand that?
Yes, ma'am.
All right. So I'm going to set your bond as follows. I'm going to set $500 on count 1 and $100 on count 2. All right?
Mm-hmm.
Good luck to you.
Thank you so much, ma'am. I appreciate it.
Oh, no hostile contact.
No prescription.
Oh, yeah, and no consumption of any unprescribed medication.
No
that good,
hostile
Mom?
Contact, no drugs, public defender appointed.
Yes.
Yes.
Thank you, Judge.
That good, Mom?
Did he understand that y'all said that? Because he walked off.
Mr. Gaines, come back here. Did you hear what I said?
Yes, ma'am.
No hostile contact, so you can't fight with your mom. If you got a disagreement or something, you're not on the same page, you gotta take a walk. Mm-hmm. And you can't take any drugs that are not prescribed to you. Do you understand that?
Yes, ma'am.
All right, good luck.
Thank you so much.
All right, you're welcome. All right, Rico Gandy.
He indicated he was hiring private, Judge.
Mm-hmm. All right, Mr. Gandy. You failed to appear on a written promise, so you're going to see your division judge for your bond, all right? And make sure you get your attorney before your next court date. Good luck. Kemuel Hernandez Novoa. All right, good morning, Mr. Hernandez. How you doing today?
Good morning. Good, and you?
Very well, thank you. All right, you here have aggravated assault with a deadly firearm. Is there a bond on this?
No,
I do not believe there is, Your Honor.
Okay. All right, is there a victim here?
Yeah.
All right, I'm appointing a public defender to represent you, and I'm setting the bond at $10,000. Good luck to you.
He has a second case, Judge. There was a warrant.
Oh, the second case. All right, well, there's the same charge. Okay. So, second case, found probable cause as well. Appointing public defender to represent you. Setting the bond again at $10,000 for count 1, $100 for count 2, Is there anyone here on the battery? No. No. And 100 for count 3. Also, no contact with any victim or witnesses. No possession of any firearms or weapons.
On both cases, Judge?
On both cases.
For both cases?
Yes, ma'am.
All right, thank you, Judge.
Thank you. Good luck.
What's up, have a seat.
All right, Jonathan Lewis.
Bonded.
Bonded. Jonathan Lewis bonded. Chadwick Ling.
Also bonded. Or no, sorry. He didn't bond, Judge. The next one bonded.
I was getting into a rhythm here.
He needs the interpreter, though.
Okay, Chadwick. Spanish interpreter? Or Asian?
No. Ling doesn't need the interpreter.
I was wondering. All right, Mr. Ling, what language? You're English, right?
Yes, ma'am.
All right. You're here today for the charge of committing domestic battery by strangulation. Anybody here on behalf of Mr. Ling? No. All right.
Judge, you signed this warrant yesterday. It's not in the system, so I don't have it. So I'm going to be asking you to set a bond since you signed the warrant yesterday.
Yes, I did, and I already set the bond. Oh, no, I'm okay. I remember the facts of this case. I have it on my computer. I'm setting the bond at $3,500. No contact with the victim. No return to the scene at this time. I have nobody here. One time to pick up your personal belongings with law enforcement.
What about PTR?
You don't qualify for it because it's domestic.
Okay.
All right, good luck to you.
Defender appointed.
Public defender's appointed.
Thank you, Judge.
All right. Juan Mosquera Mortoda. Bonded. Hector Noboa Haranda.
He's the interpreter.
Okay. Let's skip him again.
And so does Rodriguez Solis.
Also, okay, let's go ahead and get the interpreter on. Then the rest of them are interpreter cases?
No, we have Thurman is the last one that doesn't need the interpreter, then everybody else is interpreter.
Okay, Thurman. Charles Thurman.
He is on the way, Judge.
What? Anybody here on behalf of Mr. Thurman? No, okay. All right, Mr. Thurman, you're charged with simple battery. I'm appointing public defender to represent you. I'm setting your bond at $500. You're not to have any contact with any witnesses or victims in this case. You're not to return to the scene. Public defender is appointed to represent you. Good luck.
He does qualify for direct PTR, Judge, since it's not domestic. Would the court consider direct PTR in this case?
If he wants that, can you ask him if he wants PTR or bond?
Do you want PTR? Basically, you'll be released without having to pay a bond, or you can pay the bond. Which would you prefer?
PTR, please.
PTR.
All right, so PTR.
And Your Honor, I just would like to bring to your attention that the defendant and the alleged victim are neighbors.
Uh-oh. So where are you going to go, sir?
I believe this is this like a resident of a home, the Oaks? It's like a housing community, Judge, like a
resident.
citizen.
Okay.
Over 60, a senior citizen type community.
Okay, so we'll put maintain separate residences and no contact. So if you're rolling by them, don't even talk to them. Look the other way, okay?
Yes, Your Honor.
Good luck.
And I guess for the residence part, Judge, can we specify units? Because I don't want them to see the
Yes.
address. I don't want it to cause any issues.
Yes.
So maintain.
Main separate residential units.
Perfect.
Units.
Thank you, Judge.
Yes.
He, PTR.
And then
He's
everybody
PTR,
else
yes.
should be the interpreter now.
All right, let's go ahead and contact the interpreter. Oh, is that going to be through the bus?
Yes.
Okay.
Yes, she was.
Add.
Are you starting at the top, Judge, with the interpreter? Or
Yeah, Hector, I guess, is what I have. Hector Noboa, and then, I guess is the way my list is.
Good morning, Your Honor. Dalia Romero, Spanish interpreter on the line.
Hi,
Not sworn in
Dalia.
yet.
You're sworn in already?
Not yet.
Okay, let's have you sworn in.
Raise your right hand. Do you solemnly swear to translate from Spanish to English, from English to Spanish in the testimony given today?
Yes, I do. Dalia Romero, State Certified Spanish Interpreter.
All right, so we're starting out with Hector Noboa Haran. Dalia, do you need me to say the case numbers?
Yes, please, Your Honor, if you have it.
They don't have case numbers.
Oh, Osceola, they don't have case numbers.
Not yet,
That's
Judge,
fine, no problem.
I do
Okay.
have a probable cause argument whenever the court's ready.
Okay, go ahead.
Yes, Judge, I know this is a case for an injunction. There's nothing in the report to indicate when the injunction was supposed to be served, to indicate that it was active at the time, since it was a delayed reporting from 2 days prior. So essentially, my probable cause argument is verifying that there is in fact an actual active injunction in place that he's alleged to have violated.
Okay.
Su señoría, estoy argumentando que no hay causas que respaldan esto por el hecho de que esto es por un caso de una orden de alejamiento. No hay una fecha en el reporte de cuándo se le entregó la documentación para la orden de alejamiento, algo de 2 días que había sido previamente firmada, pero no hay argumento que no tenía notificación formal.
Okay, State.
Yes, Your Honor, thank you. In the report, the officer mentions court case number 22DR-1030DV. He says that it is active. He says the injunction is against the defendant on behalf of Maria Nova. And then the officer writes in the report that on the video footage of the woman's house, they observed the defendant approaching her front door, and that injunction that I previously cited states the subject is required to stay away from the residence or property of Maria, and so therefore probable cause for the willful violation of that injunction.
I guess my
Su
argument.
señoría,
Sorry.
Hold on,
En el
let the interpreter interpret what the state said.
el fiscal ha mencionado que sí hay un caso de una orden de alejamiento. El 22DR-30DB está activa, es en favor para María Nova. En el video se puede ver, el oficial podía ver una mujer, la casa de la mujer, donde el acusado se le acercó a la puerta, y en la orden de alejamiento hay instrucciones de que él no puede acercarse a ella o a la propiedad de ella.
All right, response, State.
Defense, Judge?
Yes,
Oh.
defense, I'm sorry.
Yes, Judge. Basically, the argument still goes back to date because the officers indicated they weren't able to save the video. They're relying on screenshots. That there's no indication that the screenshots show a date and time to say that these video clips, as they weren't actually to see the actual video, corresponds to a time within which the injunction was actually active, since it was a delayed reporting.
All right, I understand that's the defensive argument, but this I'm going to find that there is probable cause because of the time sequence of the wife making the report, which is evidence, and her testimony coincides with the evidence that she did have an active injunction and that she witnessed that her husband did visit her during the time that the injunction was valid. So I am going to find that there's probable cause. I'm going to set the bond at $2,500 in this cause. Of course, he may have valid defenses.
And he
So-
indicated he was going to be hiring private, Judge.
¿Puedo decir algo?
Hold on.
Un momento. La juez ha hallado que hay causas que respaldan esta acusación. Aparentemente, esto se está dejando llevar por la fecha, la hora, la secuencia de los eventos. La esposa había testificado que ella tenía una orden de alejamiento activa cuando él visitó la casa. La fianza en este caso es de $2,500. May I say something?
He indicated he was going to hire private, Judge.
Okay, he can do that. So I
El
will.
acusado ha dicho que va a contratar un abogado particular.
All right, so I will not appoint the public defender in this case, and he can hire a private attorney.
Perfect. Thank you, Judge.
Bien, yo no le voy a designar un defensor público en este caso y puede contratar su propio abogado.
Your Honor, the state would request, in addition to the bond, that there be no contact with victim, no return.
El fiscal pide que además de la fianza se le ordene a no tener ningún tipo de contacto con la víctima y que no pueda regresar al lugar de los hechos.
All right, that's granted. No contact with the victim and no return to the scene.
Bien, se da lugar a esto. No puede tener contacto con la víctima y no puede regresar al lugar de los hechos.
Okay, thank you.
All right, the next
Okay,
case
thank
is
you.
going to be Luis Alberto Rodríguez Solís. All right, you're charged with driving while under the influence and possession of cocaine. I have reviewed the arrest reports, charging affidavits. I do find that there's probable cause.
Bien, a usted se le ha acusado de manejar bajo el estado de embriaguez y tenencia de cocaína. Yo he hallado que hay causas que respaldan la acusación.
Your bond will be set as follows. For driving while under the influence, the bond is $500.
Sus fianzas son las siguientes. Por manejar bajo el estado de embriaguez, $500.
For possession of cocaine, your bond is $1,000.
Y por tenencia de cocaína, la fianza es $1,000.
The public defender is appointed.
Sorry, Judge.
The public defender is appointed to represent you.
Se le designa el defensor público para que le represente.
He does qualify for direct PTR as to both cases. Would the court consider that?
Yes.
Él es elegible para PTR en ambos casos, libertad preventiva. ¿Está de acuerdo su señoría? Sí.
Sí.
Yes.
Good luck.
Buena suerte. Eso es un programa de servicios con antelación.
All right, Alejandro David Solarte Alarcón. All right, so Alejandro David Solarte Alarcón is here for an on-view violation of probation, and his bond will be set by the division judge. The public defender is appointed to represent him.
I had it as a reset from detox for a battery and disorderly intox, Judge. I didn't have a GOP.
Oh, I misread this. I said on demand. Sorry, blame it on the no sleep. All right, so what is he?
He was detoxing, so it was just reset when he was available.
Okay, I didn't reset this, did I?
No, Judge, it was from Friday.
Okay. So what did he
Este caso
have?
se aplazó del día viernes. Aparentemente no es que está aquí por incumplimiento de libertad vigilada o probatoria,
Sí.
sino que estaba para traérsele nuevamente después de ese desintoxicamiento.
All right. Is Mr. Solarte Alarcón's wife here? No. All right, you
La
are
esposa
here
de
for,
Solar-
sorry.
Go ahead, Your Honor.
You are here for battery and disorderly intoxication.
Bien, usted está aquí por un cargo de agresión y por haber estado bajo los efectos en una forma desordenada.
Your wife is not here to testify on your behalf.
Su esposa no está aquí para testificar en su favor.
I do find that there's probable cause for the charges that you've been arrested of.
Yo hallo que hay causas que respaldan las acusaciones por las cuales está aquí hoy.
So I am setting your bond as follows. As to count one, your bond is $500.
La fianza va a ser la siguiente. En la primera causa, fianza de $500.
Your count two is $100.
En la segunda causa, $100.
You're not to return to the scene or have any contact with the victim.
Usted no va a poder regresar al lugar de los hechos y no puede tener ningún tipo de contacto o comunicación con la víctima.
You could have a one-time return with law enforcement for your personal effects.
Se le va a permitir regresar en una sola ocasión acompañado de un policía para que retire sus artículos personales.
Public defender is appointed to represent you.
Se le designa el defensor público para que le represente.
Good luck.
Buena suerte.
All right, last Spanish case and last Kissimmee case is going to be the John Doe, which is,
Carlos.
yes.
Yes, Your Honor. I don't know if you're aware, but we did get an FBI identification for John Doe.
Yeah, I have a paper here, yeah. It says here, Carlos Enrique Candel Coles.
Yes, Your Honor.
Okay. Yeah, all right, welcome. You are here today for your initial appearance for retail theft, 2 counts. One is resisting merchant, actually.
Buenos días, usted está aquí por 2 causas. Uno es por hurto de detallista y uno por resistir a la detención por el hurto de detallista.
I have reviewed the charging affidavit and I find that there is probable cause.
Yo he repasado la affidavit acusatoria y hallo que hay causas que respaldan esta acusación.
Your bond will be set as follows. 500 for count 1,
La fianza es la siguiente: 500 en el primer caso
and 200 for count 2.
y 200 en la segunda causa.
The public defender is appointed to represent you.
Se le designa el defensor público para que le represente.
Good luck to you.
Your Honor,
Buenas,
based upon the resisting of the merchant, could we just add a no return to the scene?
Oh, yes. No return to the scene. No contact with any witnesses or victims.
no puede tener ningún tipo de contacto con los testigos o las víctimas y no puede regresar al lugar de los hechos. Eso es por el caso de resistirse a que recuperaran la mercancía. Eso es todo.
Good luck.
Buena suerte.
Thank you, Judge. I believe that is all.
All right, thank you. Have a great day.
You too, get some sleep.
That'll be Friday.
She has to hook up to
Okay.
the head, to the, you can leave her on.
Okay.
Huh? Yes, ma'am, yeah.
All right, so do I leave everything on?
Yeah, she just has to hook up to the, what is that, the podium?
Yes.
Oh.
And I am connected now. Let me try that.
Does Osceola know how to hang up?
Nope, I saw she already gone, they gone?
No, they're still
Oh, yeah,
there.
hang up. Yeah, hang up, Osceola.
But if I don't know how to hang them up.
Hang up everybody.
Remove from call.
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
That'll be Friday. Okay.
You can leave her on.
Okay.
Yes, ma'am.
All right, so do I leave everything on?
Yeah, she just had to hook up to the, what is that, the podium?
Yes.
Oh.
And I am connected now. Let me try that.
Does Osceola know how to hang up?
Nope, I saw she already gone, they gone?
No, they're still there. So if I don't know how to hang up.
Hang up everybody.
Remove from call, no one here.
Yeah, you got it.
I did it. Yeah, look at you.
Yes.
All right. All right, here we are in business.
Good morning, Your Honor. Dominique Cunningham for the Office of the Public Defender.
Right. Good morning. All right, so we have somebody here. We have the first case we're calling up is going to be Taina Hernandez, right? And
Yes.
your name, sir?
Luis Mendoza. Luis Mendoza.
Okay, Mr. Mendoza, welcome. All right, we're here today for the domestic violence battery that Ms. Hernandez has. Do you want something? Do you want to say something for the court to consider?
Legal interpreter. Spanish.
Estamos aquí en el caso de Taina Hernández, en el caso de agresión. Señor, ¿usted tiene algo que quiere decir en el caso de ella?
No, solamente retirarle los cargos.
No, just to withdraw the cases.
Are you in fear for your safety?
¿Usted teme de su seguridad, por su seguridad?
No.
No.
Okay, stay. Any questions?
Yes, Your Honor, briefly. Would you like Ms. Hernandez to return home?
Sí, señor, ¿usted quiere que la señora Hernández regrese al hogar?
Sí.
And if an incident like this or a more severe incident happens in the future, can you promise to contact the police, call 911?
Si un incidente como esto volviera a ocurrir en el futuro o algo así pareciera ocurrir en el futuro, ¿usted estaría dispuesto a llamar a 911?
Sí.
No further question, Your Honor.
Okay.
Ninguna otra pregunta, su señoría. Bien.
All right, so I'm appointing the public defender to represent Ms. Hernandez. I find that there is probable cause for the charge of domestic violence battery. I have heard the information from the husband, spouse here, and I'm going to order no hostile contact and a bond of $500.
Your Honor, may I inquire why she does not qualify for pretrial release? She doesn't have any history.
All right.
Her fingerprints have not cleared.
Ok, la jueza ha determinado que se le va a designar el defensor público, ya que hay causas que respaldan la acusación de violencia doméstica, agresión. La jueza ha escuchado el testimonio del esposo aquí. Se le va a ordenar, señora, que no puede tener contacto hostil con su esposo, fianza $500. Abogada de defensa cuestionó por qué es que no es elegible para el programa de servicios de antelación y aparentemente es que las huellas digitales aún no han regresado. Así que esa es la razón por la cual tiene una fianza de $500.
Está bien, gracias.
Very well, thank you.
All right, the next case is Luz Miriam Fonseca Rodriguez. No. All right, you are here today for your initial appearance, and it is retail theft, $750 or more, and grand theft. I'm appointing public defender to represent you. I do find that there's probable cause. Your bond will be set as follows: $1,000 for count 1 and $100 for count 2. Good luck to you.
Gracias.
Thank you.
All right, Johan David Garcia Fonseca. All right, I'm appointing the public defender to represent you. I have reviewed the arrest affidavit. I find that there's probable cause. I'm setting your bond as follows. For count 1, your bond is $1,000. For count 2, your bond is $100. For count 3, your bond is $100. Good luck to you. Appointing public defender.
Thank you.
Okay. Ginari Martinez Lopez.
Sí.
All
Yes.
right. Ginari, I have reviewed your charging affidavit. You're here for trafficking in a controlled substance, possession of cannabis with intent to sell and deliver, and possession of a word I cannot pronounce. Trichohydrocannabinoids. Something like that. I'm appointing the public defender to represent you, and I'm setting your bond as follows. As to count 1, I'm setting your bond at $250,000. As to count 2, I'm setting your bond at $100,000. As to count 3, I'm setting your bond at $100,000. I'm appointing the public defender to represent you. Good luck. All right, Lina Ramirez Savera. Okay. I'm appointing the public defender to represent you. I have reviewed your charging affidavit, and I find that there is probable cause. I'm setting your bond as follows. Count 1 is $1,000. Count 2 is $100. Count 3 is $100. Good luck to you. Galina? That's the next one. Josué Manuel Ramos. I don't know. Ahigas. Okay. Appointing the public defender to represent you.
Your Honor,
Yes.
I'm sorry. My voice is gone. May I be heard? Kind of.
Yes?
Your Honor, I do not believe there's probable cause for both of these charges, only one. So we'd ask for him to be ROR'd on one of these.
Okay. State?
Well, Your Honor, the charge is possession of cocaine, and there's also possession of cocaine with a weapon. There were 4.2 grams of a white powdery substance, presumptive positive cocaine. Also found inside the vehicle where the cocaine was found was a black handgun, Stoger, with 17 9mm rounds. So I think the probable cause is met for both charges.
Your Honor, if I may.
May?
I'm not contending that there's not probable cause for possession of cocaine and there's not probable cause for the weapon, but he cannot be charged with both possession of cocaine with a weapon and possession of cocaine.
All right, I know that there's a recent case on this where they went into detail about it can be all charged offenses where, so I think that the state is actually correct that any elements met can be charged.
Your Honor, if I may.
May.
In order to charge him with both of these, it would be a violation of Blocksberger. And there is case law stating that if there are substances found, you can only be charged once. So for instance, if there were 15 rounds of ammo that were found, he could only be charged with one of those. He can't be charged with 15 counts.
Okay, no, I understand that.
And just to add, Your Honor, there were multiple baggies found, so it wasn't like there was one thing of cocaine, there were several.
And Your Honor, even though there were multiple things of cocaine, it's still possession of cocaine as a whole.
Exactly. I understand that. I understand that. I'll grant probable cause for possession of cocaine with a weapon. At the end of the day, the cocaine is there. So we'll ROR him on count 2 and grant the bond of $5,000 on count 1. No PC on count 2. Yeah.
Thank you.
All right. Is there another Spanish? Yeah.
That's one, Your Honor.
All right. It's going to be Cesario Salazar Gomez, resisting officer, DUI, and no valid driver's license. All right, I find that there is probable cause, appointment with defender, and send your bond as follows: 500 for count 1, 500 for count 2, and 100 for count 3.
Good morning, Your Honor.
Good morning. How are you doing today? Are you Clinton?
Yeah.
Dollarod?
Yes.
Dollarhead. Oh,
Would that be?
okay. Gracias, Dalia.
Thank you, Your Honor. Get some rest, everyone.
Yes.
Have a good day. Thank you.
Let's pray for no emergency warrants tonight. But I doubt it. All right. So you are here today, sir, for domestic violence battery. And do we have anybody here for you? No? All right. So I have read your charging affidavit, and I do find that there's probable cause in your case. I'm setting your bond at $500. You are not to return to the scene of the offense. You are not to have any contact with any witnesses or victims in this cause. You may have a one-time return for your personal belongings. Public defender is appointed to represent you. Good luck.
Excuse me, Your Honor. I have one question.
Yes,
So does that mean that I'm being released or I'm still contained?
you have to pay the bond, but you can go. Good
Okay.
luck.
And if I don't have anybody on the outside that can pay it for me, then what? I just sit.
Yeah, go see the judge and try to plead or something. Talk to your attorney.
Public defender. This is for you.
Problem? you changing my mind sometimes. You're fine, you're fine. All right. Shannon, how are you doing today? Shannon Shutke. All right. Oh, from Gainesville, my favorite town. Go Gators. All right, so you have somebody here for you. Hi, how are you doing today?
Your Honor, good morning.
Good morning. All right, so Shannon, you're charged with domestic violence battery. And sir, your name for the record?
Christian A. Quesada, ma'am.
All right, and do you want to say something for the court to consider?
Yes, ma'am. Shannon is a good person. She's a great partner. This is just a mistake. It shouldn't have gotten to where it is right now. I didn't want to file the charges. I want her to come home. She's a good person. Therapy is the way to go.
Okay, so are you in fear for your safety?
Not at all, ma'am.
You want to have contact with Shannon?
Yes, ma'am.
Okay. Any questions, State?
Yes, Your Honor. Has anything like this happened before?
No, sir.
Do you think there were drugs or alcohol involved in this?
Alcohol, but it wasn't that.
Do you have any fear that something like this might happen again?
No, sir.
If something does happen, can you promise to call the police, contact 911?
Absolutely, sir.
I have no further questions, Your Honor.
All right, good. Does she qualify for PTR?
Yes, Your Honor. Your Honor,
Yes.
I've spoken to her. She does not want PTR. She'd like a bond.
Okay, $500 bond and no hostile contact, right? Good luck to you.
Thank you, Your Honor. Have a good morning.
You too. Oh, point public defender. Oh, I'm sorry. She does not qualify for the public defender, so.
Okay.
All right.
We'll see.
All right, Michelle Sly. You are here today for possession of cocaine. I have reviewed the charging affidavit. I find probable cause, and I'm setting your bond at $1,000. Public defender is appointed to represent you.
Your Honor, she does qualify for pretrial release.
Okay, do you want pretrial release?
Yes, Your Honor.
All right, pretrial release it is then. Good luck to you.
Is there any conditions, Your Honor?
No.
No? Okay.
The state would like to be heard on Bielowski, Your Honor.
Okay.
So, Your Honor, the facts alleged here is that there was the first battery. After that, the victim requested the locks be changed, and the injuries in that one were a slap to the left cheek. The second charge happened later that evening, where the defendant came back into the house. He began to hit victim one, told her to watch what's going to happen if she calls the police, and proceeded to spit on a 5-month-old child, his child, Your Honor. So the state has concerns about the standard bond on this with those facts in mind.
All right. Mr. Bielowski, first of all, you were out already on bond, but it's only for driving license suspended, so it's not a related incident. I'm not gonna take any action on that. But you did have several acts of violence in one day. You don't have anybody here on your behalf, so you're not gonna be able to return back to the house. That's one thing. I do find that there's probable cause for case 2022 CF 517480, which is obstruction justice, tampering with evidence, and battery. Appointing of a defendant to represent you on that case. Oops. I'm setting the bond as follows. As to count 1, I'm setting the bond at $1,000. As to count 2, I'm setting the bond at $1,000. No return to the scene, no contact with the witnesses or the victim. One-time return with law enforcement to pick up your belongings.
Judge, I'm sorry, on the affidavit, I'm sorry, it shows battery, it got 3 next to it. So it's 3.
3 counts?
The battery, yeah.
Oh, is it?
Yes, Your Honor.
Yes,
Okay.
Your Honor.
Okay, so then it's gonna be $1,000 on each.
So 1,000 on all 4 counts? I
Yes.
mean, all 4 counts?
Yes. The same conditions, no return to the scene, no contact with the victim or witnesses.
Judge, you had two cases. Did we already?
Yeah, I'm going to the next one.
Okay.
So is that the one that occurred later in the day? Yes. So then the next one is the one that occurred later in the day, as the state had just stated, which was at 7:45. And so on this, I find probable cause on 2022 MM 98. Wait, 22 MM 98 AE. Well, this is a misdemeanor, but this one is aggravated because he has returned to the scene after prior incident. Where he spit on the 5-month-old baby, allegedly. And therefore, I'm setting the bond in that case at $5,000. No return to the scene, no contact with the witnesses. One-time return for pickup of his belongings. No contact with the victim or witnesses. No return, one-time pickup. The defenders are appointed to represent you. Good luck. All right, Jacob Fudge. All right, Mr. Fudge, you are here to.
Bromer.
Mr. Bromer, Your Honor.
Romer. Oh, Romer?
Oh, is Fudge bonded?
No, he's next.
I'm sorry?
Fudge is next.
Next, okay.
Hold on one second.
Oh, I'm sorry.
Hold on 1 second.
You got mixed up, sorry. You're fine, you're fine. Travis Brumer.
Romer?
All right, Brumer,
Yes, ma'am.
this is battery, strangulation, and domestic violence. Nobody here, okay. Public defender is appointed to represent you. I found probable cause in this case. Your bond is set as follows. It's $2,500 for count 1 and $500 for count 2. You are not to return to the scene or have any contact with any witnesses or victims. You have a one-time return with law enforcement to pick up your personal belongings. Good luck to you.
Ma'am, can I ask you a question?
Maybe.
I'm from Tampa. I don't have nobody here. I'm living in Tampa with my parents.
I can't really hear what you're saying.
Your Honor, if I may.
Yes.
Do you believe he qualifies for pretrial release?
Pretrial, right? I'm on
Pretrial.
Hold on 1 second.
Does he qualify for pretrial release?
Yes, Your Honor, he qualifies.
All right, so you can have pretrial release.
Thank you.
All right, good luck.
Thank you.
All right, now Jacob Fudge.
They need hot. They need that from the officers.
Thank you.
How you doing, Your Honor?
Hello, how are you doing?
Good, I'm good.
Good. All right, you're here today for written threats to kill or do bodily harm and assault dating violence. I have read your police report. I do find that there is probable cause. I'm setting your bond as
Your Honor,
follows.
if I may be heard on probable cause.
You may?
Is a public defender's office appointed?
Yes, public defender office appointed.
Your Honor, there's no probable cause for assault in this case. In order to charge for assault, the threat must be imminent. He wasn't even there when this happened. There were just, I believe, voice recordings that were sent. So although Your Honor may find probable cause for written threats, there's no probable cause for assault because the threat was not imminent.
Your Honor,
No. State?
Your Honor, I think that the fear was imminent because what the defendant said was she either had to leave the house immediately or he was coming home from work to kill her. So I think that does put the immediate fear of serious bodily injury in there for probable cause.
Your Honor.
Yes.
If I may, in order to prove the assault, the threat has to be imminent and they have to have had the means to carry it out. We have nothing in the four corners of the document that state any of that. Although the threats may have been made, he wasn't there. She doesn't know where he was. He could have been at work. He wasn't outside the door. He didn't say he was outside the door. He didn't say how far he was from the home. And for that reason, the probable cause for assault is not met in this case.
Okay.
And just in response, Your Honor, I think that what the defendant just said proves the fear. She didn't know where he was. She didn't know how close he was, and I think that goes to that.
All right, I do find that there's probable cause that the the assault was imminent based on the threats that he was going to be imminently harming her. So I'm setting the bond as follows. Count one.
Your Honor, he meets pretrial release.
He meets pretrial release? Okay, so he can have pretrial release on both counts.
Your Honor, can I please say something, please?
I don't think you want to say something on the record. It's being recorded.
No. I was just gonna tell you that my wife and my kids, they live with me. Like I go to work all the time. I work in the airport. It was just a heated moment. This our first time.
Okay.
Sorry, Your Honor. Thank you.
Okay. Wait, is the victim his wife? Or some girlfriend?
Is it your wife or your girlfriend?
It's not.
It's his.
No, I'm not married to her, but we've been together for 5 years.
It's his girlfriend, Your Honor.
Okay.
She's going on 6 years.
All right, so no contact with the victim.
Yes, ma'am.
All right, good luck.
Thank you, ma'am.
You can't go home if she lives there.
No, I got go to my mom's house.
Okay, that's
I have
fine.
my mom.
That's fine.
It's preacher.
All right. Herschel Gaines.
Yes, ma'am.
How are you doing today?
Doing good. How are you doing, ma'am?
Very well, thank you. All right, you are here today for false imprisonment, tampering witness, and battery. Okay? Whoever defenders appointed to represent you. I do find that there's probable cause, there's prior arrest warrants that were set in your bond. So I'm gonna set them as previously stated. Count one is going to be 3,000. Count two is 500. The batteries, nobody's here on your behalf, it's gonna be 500. And you are not to have any contact with the witness, the victim in this case. No return to the scene. Is that your residence?
Yes, ma'am. She was already in the process of dropping it,
Okay, well, for now, you could have a one-time
Okay.
return to pick up your personal belongings until that happens, okay?
Yes, ma'am. Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
Sure, another thing. Wait, hold on a second. Let me make sure.
One more.
Another case here, tampering with a witness, and on that, that's a separate count. Okay, and on that case, the bond will be 100.
Thank you, ma'am.
All right, good luck to you.
You too.
All righty. No weapons, yeah, you can do same conditions. Ricardo Trevino Hines.
Yes, madam.
I'm appointing public defender to represent you.
Your Honor, may I be heard on probable cause?
Yes.
Your Honor, I believe that there's only probable cause for one aggravated assault in this case. In order to prove aggravated assault with a firearm, the state must prove that the victim was in fear. And only Ms. Swoops provided a statement to law enforcement that an incident happened and she was in fear. The other person that was there stated nothing happened at all. So there's no proof that she was in any sort of fear. For that reason, we state that there's only probable cause for one of these charges.
I didn't even know there was two. I only have one here.
There are two cases, Your Honor. It's the same affidavit.
Okay. I had the same concerns, date.
Yes, Your Honor. I don't see the victim verbalized fear, so my response would be just the scene itself, the active shell casings, but
Anybody could have active shell casings.
yes, Your Honor. So based upon that, I don't really have a response.
Okay. All right, so I will agree that, which one will we find has PC and which one doesn't?
Your Honor, it didn't specify which victim goes to which case, so I'm not really sure that it matters.
Okay. All right, so I'll find that there is PC for 2022 CF 5169, and set the bond on that case for 2,500, and on CF 2022 5170, I find there is no PC, it's ROR.
Your Honor, are there any conditions?
I don't even know how to say not have contact with the witness, because I can't tell which is which in fear and which is not. who's in here?
Your Honor, we could specify not to have any contact with Ms. Swoops since she was the person who did give a report to
All
law
right.
enforcement.
No contact with Miss Roos? Can you say that name again?
Ms. Swoops,
Oh, Swoops, yeah.
S-W-O-P-E-S. S-W-O-P-E-S.
No contact with Miss Swoops. And I think that's all we can say because everything else that was consensual and firearms was just casings that were, they didn't look like any illegal activity. Okay. All right.
Thank you, Your Honor.
Good luck.
The state would like to be heard on this one, Your Honor.
Your Honor, the defense would also like to be heard on this one.
All right. So first of all, welcome, Mr. Ramon Ortiz. How are you doing?
Feels better, Your Honor.
Okay. I'm appointed public defender to represent you, and you are here today for child abuse and battery. And the state wishes to be heard. You may proceed.
Yes, Your Honor. So alleged in this incident are really that the defendant punched I believe it's the age of the victim was 2 years old, punched a 2-year-old in the head. And the defendant has prior convictions in the state of Florida for battery on a law enforcement officer, battery by strangulation. So the state has severe concerns about the safety of the 2-year-old child involved in this incident.
Okay. Defense?
Your Honor, we would argue probable cause as to these counts. The reason being he's charged with child abuse and battery. There was only one instance here, so he can only be charged with one of those. Again, the counts of battery are actually encompassed in child abuse, so I would anticipate the state attorney, if they're going to file on anything, they would file on the charge of child abuse, not the charge of battery. So we would ask for no probable cause to be found on the battery, and he'd be ROR'd on that count.
No.
All right. All right, so I'll go ahead and find probable cause for the charge of child abuse, set the bond at $3,000 and ROR him on the battery. No contact with a minor child, no return to, and he made no unsupervised, no contact with a minor child, no unsupervised contact with any minor children, and that's it. Good luck. Mm-hmm. Yes, ROR on the battery. All right, so Brian Conklin, how are you doing today?
I'm okay, Your Honor.
All right. You are here today for battery. And nobody's here on your behalf. I do find that you're here, that there's probable cause. You do not qualify for the public defender. So I cannot appoint them to represent you. So you have to hire your own attorney. And I find probable cause. I'm ordering that you cannot return to the scene. You cannot have any contact with the victim. Do you have your personal effects at that home?
At that place?
Yes.
All my stuff is in my car.
In your car? Okay. All right. Is your car there?
No.
All right. All right. So no return to the scene. You cannot have any contact with the victim or any witnesses, and good luck to you.
What was the bond amount, Your Honor?
500.
May I have pretrial
Judge,
release?
he does qualify for.
He does qualify? All right. You have PTR. Good luck.
Thank you.
Okay. Ian Harrison. All right, Mr. Harrison, you are here today for battery. There's nobody here on your behalf. Let me see. You do not qualify for PTR. That's not you.
He doesn't qualify.
You don't qualify either. All right, so I'm setting your bond at 500. You're not to have any contact with the victim. No return to the scene. Do you have your personal effects at that residence?
Yes, my clothes, my car, everything.
Okay, so one-time return with law enforcement to get your personal effects. Okay, good luck to you.
Your Honor, is the public defender appointed?
Public defenders appointed. All right, Jessica Mesa.
Yes, ma'am.
All right, you do not qualify for pretrial release. You're currently on bond for drug offenses, okay? I'm not gonna take any action on those because your new offense is not drug offense. Normally, if they're the same, I'll revoke it.
Thank you.
You're here for a domestic violence battery, and you have somebody here, gentlemen. What's your name, sir?
Cooper Howell.
I'm sorry?
Cooper Howell.
Oh, hi, Cooper. Did you have something that you want the court to consider before I talk to Ms. Mesa?
Yeah, I don't want the no contact thing. I want her to be able to come home. Like it was just, we both drank too much and shit got out of hand. And that's, I'm not afraid for my life or for our kid or anything like that. I just, I don't want her to not be able to come home.
Okay. All right, State, any questions?
Just very briefly, Your Honor, if something like this happens in the future, do you promise to call 911, contact the police?
What's that?
If an incident occurs in the future, do you promise to call 911, contact the police?
Absolutely.
And you're not in fear of Ms. Meza?
No,
Okay.
no.
I have no questions, Your Honor.
All right, perfect. Well, you do have a 2-year-old child together. You got to make sure that you keep your house violence-free for the benefit of the child. I'm gonna order your bond at $500. No hostile contact, and I'm appointing the public defender to represent you. Good luck.
Good.
All right, Carlos Smith,
Yes, ma'am.
how are you doing today?
Okay.
All right. You're here for domestic violence battery. Anybody here for you? Looks like nope. All right. You do not qualify for the public defender. You make too much money, okay? So I cannot appoint the public defender to represent you. And I do find that there's probable cause to for the charge of domestic violence battery. You do qualify for pretrial release. Do you want pretrial release or do you want a straight bond?
Pretrial release.
All right, so pretrial release it is. No return to the scene. Do you have your personal effects at that residence?
The residence is my house.
Okay. So maintain separate residences. No contact with the victim. Good luck. Carrie Trent. Hi, Miss Trent. How are you doing today?
Good, how are you?
All right, you qualify for pretrial release as well, so just think about that. We have somebody here on your behalf. Your name, ma'am?
Deborah Lee Trent.
All right, and what is your relationship to Ms. Trent?
I'm her mother.
Oh, okay. Hi, Mom. Anything you want the court to consider while we're addressing Ms. Trent?
Harry is a wonderful lady, a great lady, loving, kind, caring. I think she's just completely mixed into the wrong crowd and gone down a bad path. The incident started that morning when her boyfriend was at our house and attempted suicide with a stabbing incident. And Carrie got very angry at us for calling 911 and having medical come and help him. And they removed him from our property. And Carrie got very angry at us, and then proceeded to get irate because I would not let her take my car to go find him. And I just really think that she needs some mental health and substance abuse treatments until she is psychologically stable and clear of any substance abuses.
Okay. Does she live with you or she was just visiting you?
She lives at our house.
All right, do you want her to come back?
Yes, I want her to come back, but I do want her to go get some mental health and substance abuse treatment first, because I don't feel that she is going to be safe at our house without any sort of treatment.
All right, how old is
We've
she?
been trying to do mental health treatment with her for over a year. She is on medications, but she has not been going to any therapy or psychiatry appointments,
Okay.
which are virtual and very hard to want to do.
All right, she's still under your insurance?
Yes.
Okay, so you can help her get mental health treatment.
We've been trying for over a year to get her treatment, but it hasn't worked out.
All right. All right, Carrie.
So I don't know where to go from there. I don't want to send her away, but I do need her to get treatment. I don't know what to do from there.
Okay.
But I think that there are substance abuses involved as well as her boyfriend is drug addicted.
Okay. All right, Carrie, how are you doing? How you doing?
I'm here.
You're here? I know. This is a big crossroad for you, huh? This is your first time in jail? All right. Well, your mom is here. You're here. You're probably just not where you want to spend Mother's Day, right? All right. So you're 18. Normally, this is where the bird leaves the nest, right? And your mom looks like she's okay with you coming back home, but she really doesn't have to let you come back home. All right. I could order that you're not allowed to return back to the house if I wanted to. But it looks like your mom is saying she's okay with you coming back. But there needs to be some rules and regulations. Are you going to be okay with that?
I really just want to go home.
Okay. I'm sure. I mean, I have a 22-year-old and a 23-year-old, and I'm sure if I drew the line in the sand, they'd have an attack, right? But 18 is normally when kids used to leave the house, but they don't anymore. They really don't want to go home. They have a nice house. Sorry. I'm sorry.
No, that's...
I'm sorry. I'm laughing because I'm laughing because I left when I was 18 and never came back, but kids just don't want to leave anymore. Go ahead, Mom.
No, I left early and I have another daughter as well. So who moved out. If she were to come back home, I want no contact with the boyfriend at all.
Oh, okay, wait.
And I know that's a separate thing, but
Yeah, I only have certain powers.
Right.
I don't have those powers, okay? So you're gonna have to do that on your own. And you know, the one thing is that, you know, she also has her own, you know, free will. You have your own free will. You can decide that you still want to be with your boyfriend, but that may be that you can't live with mom because you're a woman now. You're 18, okay? So you're gonna have to make some choices. And your boyfriend, I don't know him. I never met him before, but if he has some issues, he may resolve those issues on his own, because sometimes if you're not stable and someone else is not stable, it's hard for you to walk when you have to carry somebody else, and you can't really walk on your own yet. So I'm not here to preach or anything like that, but what I am telling you is today we have a domestic violence case on Mother's Day with your mom. Probably not where you want it to be. And I'm gonna let you go back home. It's gonna be no hostile contact. That's no fighting, okay? Your mom feels like there might be maybe some mental health, and that might sound like a bad word, but that's actually something that we all need, self-care. And so you may benefit from talking to a therapist about life choices, things, your trajectory of life, all those kind of things. I'm not ordering that, but that's something that maybe you want to consider, okay? What I am ordering is that you need to not consume any unprescribed medication, okay? That there would be no hostile contact with your mom. And you're gonna be a pretrial release, okay? Do you guys do mental health pretrial release? or no?
Yes, Your Honor, she can be screened for mental health PTR, and if
Okay.
she does not qualify, she can be released straight PTR.
Okay, so we'll do that. Your Honor? Oh, no. Okay. All right, no. Well, then we'll do straight PTR then. Okay. What you're gonna say?
Yes, Your Honor.
Okay.
No, you're
Good.
fine. You beat me
No,
to
good.
it.
Good, sometimes I don't know. All right, so regular PTR is fine. I wish you both the best of luck, okay? I know it's difficult when you're trying to raise your child and it's hard, okay? Good luck.
Sorry, what was PTR?
It means you don't have to pay anything. She's gonna be released through a program, okay? And you're gonna monitor her, make sure she's not taking any drugs or alcohol, stuff like that, good? All right, good luck. All right, Alicia Williams, how are you doing today?
I'm doing fine.
All right. You're here today for domestic violence battery. And is anybody, oh, there you go. How are you doing today?
I'll be better once she get out.
You what? You better
I'll
when she
be
gets
better
out?
once y'all let her
Who
out.
are you? Are you her mom?
No, that's my wife.
Your wife? Okay, good. See, I should ask instead of saying. I'm always wrong.
It's fine.
The other day later I said girlfriend is the mom, so I'm always wrong.
I said I'll be better once y'all let her out.
Okay, good. All right, good. All right, so you want her out, so it means you want her to come back home, right? Yes. All right. Anything else you want me to know besides you want her to come back home?
That's it.
That's it.
Nothing happened. She need to come home.
All right. Are you afraid of her?
No.
Okay. State.
Very briefly, Your Honor, has anything like this happened before?
No.
Do you think drugs or alcohol were involved at all?
No.
If something does happen in the future, you promise to contact police, call 911 if you're in fear?
Yes.
Thank you very much. No further questions, Your Honor.
All right. Let's see. So this is, okay. All right. You do not qualify for PTR release. So I'm appointing the public defender to represent you. I do find that there's probable cause. I'm going to set the bond at $500 and no hostile contact, okay? Good luck to you. Oh, we got Kevin Berry. Who's at the sheriff? Mr. Berry, how are you doing today? All right, good. I'm sure they always kind of confuse you with the sheriff.
Oh, yes, the sheriff.
All right. So you have grand theft and an out-of-county warrant. Okay. So, and that luckily is ROR for Brevard. So Oz 2, you hardly see that. I've never seen that before. So as to the case for here, I'm appointing public defender to represent you. I found that there's probable cause for the grand theft in third degree. Your bond is set at $500. And as for your out-of-county warrant, as is previously said, you've been arrested on it for the Brevard case, and you are ROR'd. Good luck to you.
Mark Brown is mental health.
Mental health, Mark Brown, okay. So I have reviewed his arrest affidavit. I'm appointing the public defender for both of his cases. As to possession of cocaine, I find probable cause, and drug paraphernalia, I find probable cause. Send count 1, the bond at $1,000, and count 2, $100. On his second case, it's petty theft. I'm setting the bond at $100.
Your Honor, he has a third case.
A third case? Where is it? What is it?
It's a
Oh, there it is. Okay, I see it. The grand theft, $100. We did federal reporting for all 3 cases. All right, Wesley Bryant.
Good afternoon, Judge.
Good afternoon. Okay, a little bit of bad news for you. It's just, know your judge. Whenever you come in here with on bond, if you have a new offense, but it's a different type of case, I leave it alone. But if it's the same type of offense, that means you're not learning your lesson, I revoke it. Mm-mm-mm.
One second, Judge.
What happened?
We're not gonna put that on the record. We're not, you can talk to your public defender about it, but we're not gonna put that on the record.
I know, you're not gonna be happy. So I'm revoking all of your bonds. Mr. Schwartz is not gonna be happy with you because he probably worked hard to get you all those bonds.
I was doing my.
You were what?
Nothing, Your Honor.
Nothing. Okay. Yes. Probably better that I didn't hear that. But on your new cases, you have some bonds, but maybe you get to plead them all out when you go to court. On your new cases, I'm appointing the public defender to represent you, which you probably get Gary again. But for count 1, it'll be $4,000. Count 2 will be 1,000, and count 3 is 500. Good luck to you.
Okay, tell your
Revoke all the other ones. All righty, next person.
Judge.
Yes.
Can I ask for white noise? I need to speak to you. It's very important.
No. No. Have a good day. All right, DeAndre Butler.
Do you have a booking number, Your Honor?
Yes. 22010468.
Bonded.
Okay. Cameron Constant. Mr. Constant, good afternoon. You are here today for sale and delivery of cocaine. I did review your warrant. It's already there's been a finding of probable cause already, and the bond is set at 1,000. Public defender is appointed to represent you. Good luck. All right. Carlos Cortez Cannon. How are you doing today? No? You didn't look like a Carlitos.
Booking number, Your Honor?
Booking number is 22010456.
Bonded.
Bonded. All right, so you must be, ooh,
Doriska Melizer.
yes, very nice name, Melizer.
Thank you.
Your Honor, may I be heard on probable cause?
You may?
Public Defender's Office appointed.
Yes.
Your Honor, the defense is going to state that there's no probable cause for a burglary of an unoccupied structure or an unoccupied dwelling. In order to prove a burglary, there has to be a crime therein, and that crime must be something other than a trespass. There was no damage here, nothing was stolen, there was no forced entry, he was just sleeping in the room. So I would state that there's only probable cause for a trespass.
Response?
Your Honor, based upon that, the state will request a 24-hour reset to have the officer supplement with probable cause for the burglary.
And Your Honor, we would object to a 24-hour reset. The reason being, in order to get a 24-hour reset, there needs to be something in it that states extraordinary circumstances to prove that the affidavit is not complete. There's nothing within the four corners of this affidavit to prove that it's not complete. All of the information is in it. It states that there was no forced entry. It states that he came in because it was unlocked. It states that he was sleeping in the room upstairs. There was nothing stolen. Everything is in that document. There's nothing to be supplemented.
Your Honor, I think that the mention of the fact that he was a previous tenant of this this place where he had broken into, if the officer expands upon that, that might lead to the facts required for the burglary.
And Your Honor, if I may?
Yes.
If the officer were to expand upon that, it would lead to a trespass, which is not enough for a burglary.
All right. I will find that there's no PC for count 1 and find that there is a PC for count 2. Well, was there a prior warning?
And Your Honor, I believe that it was a burglary of an unoccupied dwelling as well as a trespass after warning. That was the second count.
But was there a prior warning?
Your Honor, may I have a second? Your Honor, The affidavit does cite a court case number in which the client was evicted.
Actually, Your Honor, if I may, the last sentence of the report says, "See Deputy Miles supplement." Maybe that has the information required for burglary or.
Okay. You know what? I'll grab 24 hours.
Thank you, Your Honor.
There's a supplement that we're missing.
And Your Honor, the defense, just for the record, would put on the record that that supplemental report should have been provided.
I understand. All right. So we'll do a 24-hour reset for probable cause.
I'm gonna bring it back tomorrow. Excuse me. You need to speak to me. I'm not gonna be the person who's here tomorrow. I'll leave notes for them. Okay?
All right.
Your Honor, is there a bond in case he's able to
Oh, sure.
get the bond before tomorrow?
Yes. So for the count 1, the bond is 1,000, and for count 2, the bond will be 100. Yes, reduce it. 1,000 and 100.
You're coming tomorrow for them to argue again because the state is saying that there's more information. You'll be here tomorrow. If you can bond out, then you won't be here tomorrow. With $1,000 and $100.
All right. Matthew Ferris.
Oh, ma'am.
How are you doing today?
Pretty good.
Good. All right. So, lucky for you, you have 2 failures to appear, but your division judge was nice enough to give you a bond. So your bonds are as follows: $5,000 for count 1 and $250 for count 2. Good luck to you.
Madam, they owed me on that, and that was like 8 months ago, and I thought it was done, and then I done my friend house yesterday, and they made my name out of warrant. I didn't know I had to go to very cool. That was 8 months ago.
Yeah, well, public defenders appointed to represent you, and they can figure out what happened, okay? Good luck to you.
You have a bond.
All right, Jose Hernandez Gomez. All right, Mr. Gomez, you are here today for burglary of occupied dwelling and criminal mischief. Public defenders appointed to represent you. I have reviewed the charging affidavit. I do find that there's probable cause. Your bonds are as follows. Count 1 is $2,500 and count 2 is $500. Good luck to you. All right, Mr. Green, how you doing today?
Not good. I shouldn't even be here, man.
Oh, you shouldn't even be here. Well, you might be here a little longer because you were out on drug offenses and you got some new drug offenses. So I'm going to have to revoke your bonds.
Your Honor, if I may, what is the date on the new warrant? I wasn't able to see that.
The new warrant. It says here, let's see, Elaine Barber on.
I have the case number, Your Honor.
Okay.
So it appears he's out on bond on 22 CF 464AO.
Have that. But what is the new warrant case?
And Your Honor, I did see just a brief synopsis and there was no date on that. And for that reason, we would ask for no reason or no action to be taken on the case he's out on bond on, because we don't know when this new warrant, the incident occurred. It could have occurred before the incident in which he's out on bond for.
Case number for the new one, Your Honor, is 2695.
And Your Honor, I did look at clerks and I couldn't find any extra information either.
But it's still access the same.
What he said?
He said he was ROR'd. It was a 33, Your Honor.
And I didn't even catch a warrant. I didn't even catch a warrant.
Your Honor, he was released on a 33-day motion on the one that he's out on.
Oh, you did 33 days on the ones that you're out on? These? Okay. All right, well, I always feel like that's fair game. So I won't revoke your bond then. Y'all lucky. All right, so for your new cases, there's already a warrant. That was probable cause warrant, so your new bonds are gonna be 10,000, for count 2, and 2,500 for count 1. Public defender is appointed to represent you. It has a condition of do not return to the scene, do not possess any illegal drugs, distribute or sell illicit narcotics, and I'll take no action on the case that you're out on, you're ROR'd on. Lucky day. All right, Howard, McKeewee Howard. How are you doing today?
State would like to be heard on this one, Your Honor.
Okay. All right, so I'm appointing the defendant to represent you. State wishes to be heard. You may proceed.
Yes, Your Honor, the state would ask for no bond on this case for the facts and his criminal history. So the facts alleged are that he dumped gasoline on the victim and chased him around with a lighter. While en route to the booking center, he said that he would kill Michael the next time he saw him. Michael's the victim, and he would dismember him. He then told the officer he's going to get out on bond the next day, and he will find Michael because he knows where he sleeps and will burn his body. Your Honor, the defendant has prior convictions for battery 3 times, a bunch of drug cases, an aggravated battery, assault with a weapon, burglary of a structure. So the state has the gravest concerns for this victim's safety, and for that reason, we ask he be held on no bond.
Your Honor, if I may.
You may.
He is entitled to a bond in this case. According to case law and statute, he's entitled to a bond. So we'd ask for a bond to be given. This was charged as an aggravated assault, not anything more egregious than that. So we would ask for a reasonable bond to be set.
Okay. All right. I do have to set a bond in this case, but I can consider the safety of the community, and based on the statements to the law enforcement officers, I did have concerns as well. I'm setting the bond at $25,000. We're not to consume any drugs or alcohol while out on bond. No contact with the victim. And no possession of gasoline or fire, lighters, or arsonary tools.
I wouldn't say anything on the record. I understand this is not.
Or firearms, or weapons. I'm trying to think of everything.
Yes, it's a very high crime.
So with the bonds, know how much that be?
Good luck.
2,000.
Public defenders appointed.
Then talk to your public defender to see if you can get a bond reduction. Talk to your public defender.
All right, DeAndre Jackson. Are you DeAndre?
Yes, ma'am.
All right. All right, Mr. Jackson. You were out for drug offenses, including possession of cannabis, tampering with physical evidence, resisting officer without violence, and possession of drug paraphernalia. And then you were arrested for possession of cocaine, possession of firearm, and convicted felon. I'm revoking your bonds. I'm appointing the public defender to represent you. I find that there's probable cause for your new law violations, which include the charges that I just listed. And I'm setting your bond as follows. For count 1, your bond is set at $5,000. For count 2, your bond is set at $100. For count 3, your bond is set at $100. And for count 4, your bond is set at $100.
Do I have a date or anything scheduled for the ones I was out on bond for?
Talk to your attorney, but not right now. She's busy.
I don't have that in front of me. I'm not to call your public defender. Yeah.
Looks like no is the answer. All right. This is Joel Daviel.
Yes.
Okay. You are here today for her driving while license suspended as a habitual offender. Okay, I'm appointing public defender to represent you. and I do find that there's probable cause, I'm setting your bond at 1,000. And you also have, for that case, and then you also have trafficking controlled substance, possession of cannabis with intent to sell and deliver, and that possession of the word I can't pronounce, tetrahydrocannabinoloids. For that case, count one, I'm setting your bond at 250,000. For count two is 100, and for count three is 100. Public defender is appointed to represent you. Good luck. Jamie Leon Mejia. No, you didn't look like Jamie.
Nelson.
Right here. All right.
Booking number?
22010455.
Mr. Nelson, what happened?
Posted bond.
Okay.
How are you doing today?
Charles Frederick Nelson. All right. You do look like a Charles Frederick. Possession of methamphetamine. All right. I reviewed your charging affidavit. You also have, oh boy. Okay. You're not going to be happy. I have a few cases. So, Mr. Nelson, you were out on bond. Did you do 33 days on your prior cases?
Yes, sir. Yes, ma'am.
All right. Well, then I won't take any action on your 33 days because you had the burglary of a structure, petty theft, and possession, which you state hasn't filed on. But then you also have a new possession of meth and drug paraphernalia. I'm sorry? Mm-hmm. Yeah, he was released to ROR. All right, so I don't know. Well, I don't know. Does he has court dates already? They filed on that case?
You gonna take your bond away or not?
All right, so I'm gonna go ahead and revoke the bond because you seem to have a lot of the same offense. So I'm gonna revoke your ROR status on 2021 CF 1320080. Revoke ROR. You also have possession of meth and possession of drug paraphernalia on CF 2022 4646. The bond is 25,000 on count one and 500. I'll make that a ROR on count two. And public defender is appointed to represent you on that case. Then you have an additional possession of meth case in the CF 2022 5181, and that bond is 1,000. Public defender is appointed to represent you on that case as well. Good luck to you, sir.
This case, when where she revoked her bond.
Yeah, when is that?
You have case management conference coming up on your case that I revoked the bond on.
It was this week. I'll let them know you're in jail.
Okay. All right. Can you write that on there? The 12?
Jose Rodriguez. You're next.
Mm-hmm.
Hey, let's see. Catch up on my papers over here. I got so far behind. So, Mr. Rodriguez, you are here for burglary of a conveyance and burglary of a structure and loitering and prowling. Okay? And you do qualify for pre-trial release. That's amazing. You're lucky. For everything? For everything?
Yes, Your Honor.
Wow. You got lucky because this would have been expensive. You want pre-trial release? Or you want bonds? It's kind of like a mini probation. Do you want bonds?
Pretrial release, Your Honor.
Pretrial release, okay. So I find probable cause for the burglary of a conveyance, burglary of a structure, and loitering and prowling, and you will be on PTR. Good luck to you.
Any conditions, Your Honor?
Any conditions? How old are you?
I'm 19, Your Honor.
19?
Yes, ma'am.
You have a job?
I was, but as of yesterday, I was supposed to go to the interview, but no.
No, okay. Well, you are to attempt to maintain lawful employment, not any other type of employment.
Yes, ma'am.
Did you graduate from high school?
Yes, ma'am. I want to be a judge.
You want to,
That's what I wanted to be before my life, crumbled.
okay, well, so then you need to maintain lawful employment or attempt to maintain lawful employment. So you'll continue to show to PTR your attempts at gain to gain lawful employment. You are to not to consume any drugs or alcohol while on PTR.
Yes, ma'am.
Okay, and that'll be your conditions. Good luck.
Yes, ma'am. Thank you very much.
All right. Jimmy Lee Rowe. Is that you? How are you doing today? All right, so you do not qualify for PTR. You are here today for petty theft. And whenever I have these paper clips, it means you got some more stuff here, but no. It's just your petty theft. I'm appointing public defender to represent you. I do find there's probable cause for your case. You have prior convictions. I'm setting your bond at $500. Good luck to you.
Just one charge, man.
What happened? You're welcome. 500.
Under Matthew Salazar refused.
Refuse.
State
Okay.
would like to be heard on Mr. Salazar, Your Honor.
All right, go ahead.
So the facts alleged in the police report are that he told the victim that she was going to die today, it's over for her, and he attempted to enter the victim's room with a steak knife and a fork in his hands, and he made mention about someone eating the victim's daughter. I took a look at his criminal history, Your Honor, and he has an out-of-state conviction for involuntary manslaughter, a conviction for escape, two convictions for parole violations, and was actually arrested on the involuntary manslaughter for murder while committing an F1. So I would like no bond, if that's not possible, as high as the court is willing to set.
Your Honor, if I may.
Okay.
Again, he is entitled to a bond, so we would ask for a bond to be set, a reasonable bond. And in addition, it looks like there may be some mental health issues here, so I would like the court to take that into account as well.
I have reviewed this case, specifically all of the cases that he's out on bond: aggravated battery with a deadly weapon or causing great bodily harm, aggravated battery with a deadly weapon or causing great bodily harm, which is case numbers 2022 CF 003-73480. And taking that into consideration, along with the facts of this case, I'm first of all revoking the bond in CF 2022 373480. And I'm setting the bond, the new law offense, at $150,000. I believe that is reasonable. No contact with the victim, no return to the scene.
We had no weapons, Your Honor.
No weapons or firearms. And no leaving the jurisdiction of the state of Florida. And that's it. Point with defendant to represent them. All right, this is Marcus Thomas.
Yes, ma'am.
All right. You are here today for possession of cocaine and possession of cannabis. And then you were arrested for sale and delivery of MDMA, ecstasy. So, unfortunately,
Your Honor, may I be heard?
you may.
Your Honor, we would ask for no action to be taken on the case that he's out on bond on. The reason being, this is not a new law offense. He bonded out on the possession of cocaine and the possession of cannabis on March 28th. The warrant for that he was arrested on, that was issued on March 22nd. So that warrant was issued even before the original incident, the possession of cocaine and the possession of cannabis occurred. So because it's not a new law offense, we would ask for no action to be taken.
Okay. Good argument.
Additionally, I believe, he was out on bond, it's not a 33.
Okay. All right, you got lucky, sir. I normally revoke your bond if you have the same or similar offense, but your attorney, who I've appointed, is correct. We just caught up with you a little bit late, allegedly. So I'm going to go ahead and take no action on your bond case. There is a warrant already you've been picked up on, and you have a bond of $1,000 for the new law offense. And any conditions on here on the warrant is, well, they don't have it, but I'm gonna add no possession of illegal drugs. You're not to sell, distribute, or possess any illegal drugs.
Yes, ma'am.
All right, good job.
Forrest Walker bonded?
Wait, what, Walker bonded?
Yes.
Okay, good.
Charles Wright also bonded?
Woo-hoo.
Mario Reed? Not?
Dario Reed bonded?
They said pre-trial release.
Okay.
Gomez.
Making it go faster.
Your Honor, do you have a Gomez on your list?
Not yet.
Okay.
What about Wandy Armand?
Your Honor.
Oh, hold on. It's emergency.
Your Honor, I'm gonna go in the back.
All right, I gotta take a break.
I'm gonna step out, Your Honor, use the restroom.
All right.
Brandon Gomez, he bonded.
Judge Laurent.
Thank you.
Whoever that is, Carlos bonded too. He said Reed bonded. Reed bonded. Walker bonded.
What?
He was gonna kill her.
A knife and a fork?
Do we know where Lake is? Oh. Thank you.
You getting your orders? Okay.
Dying over her. My voice is going.
Yeah, but let me make sure.
I'm trying.
I'm the only one that got 2 E's in my name.
almost done. Yes. We might still make it to 2 o'clock. 1:30.
That clock ain't right.
That's not right?
Oh, yes, it is. Girl. What it say? What he got?
Yeah, find your friend.
I don't know where he is.
I don't remember him leaving. Did he leave?
He said he was gonna step out, but he'll be back.
He don't know that I'm that quick. Like, I'm not playing around with these little warrants. It's the same case too. It's so sad. No, the same thing. But they just wanted more evidence. They wanted to expand the search warrant. I know. That was easy. I already knew all the facts of the case. I'm like, sure, she reads that one. Gotta watch the news tonight. You want to find him for us?
I can go look for him.
Yeah.
He might be out in the hallway.
Maybe. Maybe he went back to his office. Oh my goodness. I hope not. Found him.
Yeah, I was trying to go down a floor.
All right, ready. All right, so welcome, Mr. Juan de Armand. Yes. Okay. All right, so you are here for voyeurism, appointing the public defender to represent you. And let me see something. I think I missed some of these PTR people. Does he qualify for PTR?
No, Your Honor.
No. All right. So your bond is set at 1,000. You are not to, wait, hold on a second. You are not to return to the scene. You're not to have any contact with the victim in this case. Okay? Good luck to you.
get a pen?
All right, this is Fermin Arroyo Velasquez, correct?
Yes, Your Honor.
All right, I'm appointing public defender to represent you. You have a trespass after warning.
Your Honor, the
Yes.
state has extended an offer of an adjudication of guilt, credit for time served, no return in court costs.
All right, does he wish to accept that?
Yes, Your Honor.
Yes, Your Honor.
Oh, thank you. All right, Mr. Arroyo Velasquez, I'm showing you this plea form. It's Tel State of Florida versus Fermin Arroyo Velasquez. Do you recognize this document?
Yes, Your Honor.
Did your signature at at the bottom?
Yes, Your Honor.
And prior to signing this document, did you have the opportunity to review this plea form with your attorney?
Yes, Your Honor.
Did your attorney explain to you the rights that you're giving up by entering this plea today?
Yes, Your Honor.
Did you explain to you the rights that you're giving up by entering the plea?
Yes, Your Honor.
Did you understand those rights?
Yes.
Did anyone force you, threaten you, or coerce you to enter this plea today?
No, Your Honor.
Did you understand that by entering this plea today, you could be subject to deportation?
Yes, Your Honor.
Do you understand that if you were previously convicted of a sexually motivated offense, it could subject you to commitment?
Yes, Your Honor.
And how do you wish to plea?
No contest.
All right, state factual basis?
Yes, Your Honor. On Saturday, May 7th, 2022, at about 4:12 p.m., deputies were dispatched to a 7-Eleven where the defendant was observed. He had been previously trespassed from the property after an accusation of shoplifting. He refused to leave, so the deputies arrested him.
All right. All right, so this time I accept your plea of no contest. If I enter into this plea freely and voluntarily after having the opportunity to review this plea form with your attorney, are you satisfied with your attorney?
Yes, Your Honor.
Okay, so you are satisfied with this attorney, and I'll sentence you as follows. I'll adjudicate you guilty of trespass after warning. I will sentence you to, how many days does he have in? 2 days in the Orange County Jail with credit for time served for the 2 days that you've already spent. I'll order that you not return to the scene of the offense and court cost. You'll have 365 days to pay your outstanding financial obligations, and good luck to you. You have 30 days to appeal judgment and sentence. It must be in writing. If you cannot afford an attorney, will be appointed to you. Good luck.
Thank you. Have a good day.
Good day. All right, Joshua Barnes. Is that you? All right, Mr. Barnes. All right, you do not qualify for PTR. You have trespass on property after warning. And you now have another trespass on property after warning.
Your Honor, if I may.
You may.
The state has extended an offer of credit time served, adjudication of guilt, no return in court costs to both the case that he's out on bond on and the case that we're here for. Would the court be willing to take pleas to both of those cases?
Yes. What about, and the resisting?
Yes, Your Honor.
Okay, so all-inclusive package. Good deal. All right, Mr. Barnes, I'm showing you two plea forms because you have two cases. You see that?
Yes.
All right. Are these your signatures on both of these forms?
Yes.
And prior to signing these forms, did you have the opportunity to review them with your attorney who's been appointed to your case?
Yes.
Did your attorney explain to you the rights that are on these plea forms?
Yes.
Did you understand them?
Yes.
Do you understand that you're giving up the right to your constitutional rights that are listed on these forms?
Yes.
Which is the right to remain silent,
Yes.
the right to have the state prove these charges against you.
Yes.
Do you also understand that by taking this plea today, you're giving up your right to go to trial?
Yes.
You understand that if you've been that by taking this plea also, you could subject yourself to deportation if you're not a U.S. citizen?
Yes.
You also understand by accepting these pleas, if you've been previously convicted of a sexually motivated offense, you could subject yourself to civil commitment.
Yes.
All right. And how do you wish to plead to these charges today?
No contest.
Okay. And just to make the record clear, you are pleading to 3 charges, which include 2 counts of trespass after warning and 1 count of resisting an officer without violence, correct?
Yes.
All right. All right, so I'll accept your plea of no contest to all 3 charges, and I will sentence you as follows. I'm adjudicating you guilty. How much time does he have in? Okay. I'm adjudicating you guilty, sentencing you to 2 days in the Orange County Jail with credit for time served for the 2 days that you've already spent. I'm ordering you not return to the scene of the offense for both cases and court cost. You'll have 365 days on both cases to pay your outstanding financial obligation. You have 30 days to appeal judgment and sentence. Must be in writing. If you cannot afford an attorney, one will be appointed to you, and good luck, sir.
Your Honor, Kenneth Lake, medical.
All right. Kenneth Lake is medical. Right now, he is here for a simple assault and resisting officer without violence.
Your Honor, if I may?
You may?
Can we roll this because it's a pleable?
All right, so we'll go ahead and roll this for his reset for tomorrow.
And Dennis Lindenholm refused.
Refuse. Okay.
Your Honor, we'd also ask to roll this, same reasoning.
All right, roll to tomorrow. Richard Rivera Pagan.
How you doing, ma'am?
Good, and yourself?
I'm trying to get my life right. I don't know. It's kind of impossible, you know?
Oh.
I just keep coming back here. I'm just trying to see if I can just...
Your Honor, may I be heard on this case?
Yes?
Your Honor, the state has extended an offer for Mr. Rivera. The state's offer is an adjudication of guilt, 30 days in the Orange County Jail, court costs and no return. Your Honor, this is a trespass after warning. We'd be asking if the court would be willing to do an AG no return credit for time served.
Yes.
Yes, Your Honor, I just want to put my justification on the record. I have no problem with the bench offer.
Okay.
The defendant does have an extensive criminal history with multiple, I think he's got 11 trespasses, an exposure to sexual organs, some violent crime, drug offenses. That's why the offer was jail, because the criminal history is extremely extensive.
I'm homeless, ma'am. I mean, like, I've been homeless for 15 years, and I mean, like, I've been working on my case. I mean, if you guys can help me.
Sir.
Okay. All right, let's take the plea form.
Your Honor, he hasn't signed it yet because we were going to ask that if the court would be willing to do that.
Be willing to take a plea.
May I
You gonna do it? You gonna do it?
This is Richard O'Brien Rivera Pagan.
I don't know what she's gonna do.
All right. Mr. Richard O'Brien Rivera Pagan, I'm showing you this plea form entitled State of Florida versus Richard O'Brien Rivera Pagan. Do you recognize this document?
Yes, ma'am.
All right, this is your signature at the bottom?
Yes.
And prior to signing this document, did you have the opportunity to review this plea form with your attorney?
Yes, ma'am.
And did she explain to you the rights that you're giving up by entering this plea today?
Yes, ma'am.
Did anyone force you, threaten you, or coerce you to enter this plea today?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication that would prevent you from understanding what is happening here today?
No, ma'am.
Did she explain to you the rights that you're giving up by entering this plea?
Yes, ma'am.
Okay. Do you understand that by entering this plea, you're waiving your constitutional rights to a trial?
Yes, ma'am.
All right, and do you also understand that by entering this plea, you could be subject to deportation if you're not a lawful U.S. citizen?
Yes, ma'am.
All right, so at this time, how do you wish to plead to the charge of trespass after warning?
No contest.
No contest.
All right. How much time does he have in?
2 days.
All right. 2 days. All right, this time I accept your plea of no contest. I find that you entered this plea freely and voluntarily after having the opportunity to review this plea form with your attorney. Are you satisfied with your attorney?
Yes, ma'am.
Okay. All right, so I'm gonna adjudicate you guilty or sentence you to 2 days in the Orange County Jail with credit for time served for the 2 days that you already spent. I understand the state's concern, and I understand that you want to get your life together, but if the state is correct about your criminal history, there's no justification for those things. You really want to get your.
Thank you.
You do need, if you need to make active steps. We can't really make those active steps for you. You need to do that, okay?
Yeah.
But you can't do that here in the jail.
That's
So,
impossible. You got
yeah.
1,000 people on you.
all right. So good luck to you. You have 30 days to appeal judgment and sentence. It must be in writing. If you cannot afford an attorney, it won't be pointed to you. Good luck.
Okay, thank you.
You got a year to pay. No return. All right. Katrina Barkley. You? All right. You're here for an out-of-county warrant. Ooh, baby. Out-of-county warrant. Out-of-county judge has already set your bond, and it is $15,003. Good luck to you. All right. Travis Beal.
Yes, ma'am.
All right, you're here today for violation of probations, out-of-county warrant, 2 violation of probations. And so I'll appoint the public defender to make sure you have a smooth transition, but those bonds have to be set by your out-of-county judge. Good luck to you.
Stallings, mental health.
Stallings is mental health. All right, so go ahead and reset that for tomorrow.
Your Honor, we can proceed if you would like to on that case. We already rolled it once.
Okay. So for Stallings, Mary Jim Stallings, we'll go ahead and. Okay. Yeah, no contact. Let's see, I signed this. That's from yesterday. Let's see. All right, so this is attempted second-degree murder and aggravated battery with a deadly weapon. The bonds are set for none. So at this time, what did we say it was she refused? Mental health. All right, so due to mental health concerns, we'll go ahead and have this bond set by the division judge. Huh? No contact with victim, but it's gonna be set, no condition right now, because it's gonna be set by the division judge. Bond will be set by the division judge. All right, Jack Thomas Clark, violation of probation. All right, so that's gonna be set by the division judge. Public defenders appointed to represent you. Stacy Thomas, how are you doing today? Great. Public defenders appointed to represent you, and your bond will be set by your division judge.
Can I ask Your Honor anything?
No, because I don't know anything about your case. Your division judge will set it.
Yes, and then there'll be no.
All right, Kieran Allen. All right, Mr. Allen, you're here today for disorderly conduct. Public defenders appointed to represent you, and your bond is $250.
Your Honor, if I may.
You may.
The state has extended an offer of an adjudication of guilt, credit for time served, court costs, and no return. Would the court be willing to accept that offer?
Oh, yes. Let's do it.
I know.
Oh, thank you. All right, Mr. Allen. I'm showing you this plea form. It's titled State of Florida versus Kieran Torrell Allen. Do you recognize this document?
Yes, ma'am.
Are your signature at the bottom?
Yes, ma'am.
And prior to signing this document, did you have the opportunity to review it with your attorney?
Yes, ma'am.
She explained the rights to you that are listed on this form.
Yes, ma'am.
She explained the rights that you're giving up. Did you understand that you have the right to have a trial and call witnesses in your case?
You have that right. You're gonna be giving it up because you're resolving your case.
Yes. Yes.
All right. And you understand that you're giving up those rights in order for this to take this plea?
Yes.
All right. Did anyone force you, threaten you, or coerce you to enter this plea?
No, ma'am.
Are you under the influence of any drugs, alcohol, medication?
No, ma'am.
Understanding what is happening here today.
Yes.
Do you understand that if you're not a U.S. citizen, entry of this plea is subject to deportation?
Yes, ma'am.
Do you also understand that if you've been previously convicted of a sexually motivated offense, entry of this plea could subject you to civil commitment?
Yes, ma'am.
All right. So at this time, how do you wish to plead to the charge of disorderly conduct?
No contest.
All right. I accept your plea of no contest. I find that you entered this plea freely and voluntarily after having the opportunity to review this plea with your attorney with whom you say you're satisfied. And I'm going to sentence you as follows. I'm going to adjudicate you guilty. How many days do you have in?
2 days. Two.
I'm going to sentence you to 2 days in the Orange County Jail with credit for time served for the 2 days that you've already spent, plus court costs, and you may not return to the scene. Your total financial obligation will be due in 365 days.
Okay.
You.
Thank
You have 30 days to appeal judgment and sentence. It must be in writing. If you cannot afford an attorney, it will be appointed to you. Good luck. All right, Mark Kane.
Okay.
How are you doing today?
Doing good, man.
Good. So we like to hear.
Your Honor?
Yes.
The state has extended an offer on this case as well.
All right.
Adjudication of guilt, credit for time served, court costs, and no return.
All right, let's take care of it.
Your Honor, you know he has an open case also.
Okay.
He has an open case also. He's out
Okay.
on bond.
He's out on bond, so what's going to happen with the bonded case?
Your Honor, would the court be willing to take a credit time served plea on that one as well? It is also a disorderly conduct.
Is it
And he's stating that he did serve 15 days for that one.
state?
Your Honor, I would leave that in your discretion. I don't think without having that case file in front of me, I'm in a position to say yes or no.
I mean, I don't mind. We don't have that case here. It's not one of, I don't mind. I mean, it's one less case to deal with.
Yes, Your Honor, I have spoken to Mr. Kane. He stated that if the court would be willing to do so, he would like to plea out on that case as well.
All right, what's the case number?
The case number is 2022 MM
Oh, hold on a second. 2022 MM.
002686 AO. Oh, I have on the paper that it's a disorderly conduct.
Okay. So he's pleading to this case. Oh, that was the one I had here. Okay. So he's pleading to the new law violation, disorderly conduct, plus the one he's out on bond for, which is the 2022 2686. Okay, perfect.
And yes, Your Honor, I was the attorney on the case that he's out on bond for. I am familiar with the facts of the case, so I'd stipulate to a factual basis for the purposes of the plea. May I approach?
Amen. Okay. Oops. I'm writing his name on the top, okay?
Yeah, thank you, Your Honor. I apologize.
You're fine. All right. Mr. Kane, I'm showing you two plea forms. They both titled State of Florida versus Mark Kane. Are these your signatures on the bottom?
Yes, ma'am.
And prior to signing these documents, did you have the opportunity to review them with your attorney?
Yes, ma'am.
The attorney explained to you the rights that you're giving up by entering these pleas today.
She did.
Did she explain to you that you had the right to a trial and to call witnesses in your defense?
Yes, ma'am.
Did she tell you that the state had to prove each and every element against you beyond reasonable doubt?
Yes, ma'am.
Are you under the influence of any drugs, alcohol, or medication that would affect your ability to think or make decisions today? Did anyone force you, threaten you, or coerce you to make this decision today?
No, ma'am.
Do you understand that if you're not a U.S. citizen, entry of these pleas will subject you to deportation?
Yes, ma'am.
Do you also understand that if you've been previously convicted of a sexually motivated offense, entry of these pleas may subject you to civil commitment?
Yes, ma'am.
How do you wish to plead to the two charges of disorderly conduct?
No contest.
All right. And your attorney stipulates a factual basis for both counts, correct?
Yes, Your Honor.
All right, so at this time, I accept your plea of no contest. Find that you enter this plea freely and voluntarily. After reviewing your cases with your attorney with whom you say you're satisfied with, and I'm going to sentence you as follows. As to 2022 MM 2686, I adjudicate you guilty, sentence you to 15 days in the Orange County Jail with credit for time served for the 15 days that you've already spent. Court cost? Oh, 17 days. 17, bonus. No return and court cost. As to the case for this morning, I'm adjudicating you guilty, sentencing you to 2 days in the Orange County Jail with credit for time served for the 2 days that you've already spent, and court costs and no return to the scene. For both cases, you have 365 days to pay your outstanding financial obligations. You have 30 days for both cases to appeal judgment and sentence. It must be in writing. If you cannot afford an attorney, one will be appointed to you, and good luck, sir.
Thank you. Thank you, ma'am.
All right. Last case. Sorry. Oh, can I make it? Sebastian Fernandez.
Yes, ma'am.
How you doing today? In a plea.
Blessed.
You're blessed. That's yes, you are. All right. Disorderly conduct. All right, counsel. Gonna put the offer on the record.
Your Honor, the state's offer that was given to us is an adjudication of guilt, credit for time served, no return, court costs.
All right. Mr. Fernandez, I'm showing you this plea form. Do you recognize this form?
Yes, ma'am.
Is that your signature at the bottom?
Yes, ma'am.
And prior to signing this plea form, did you have the opportunity to review this with your attorney?
Yes, ma'am.
Did your attorney explain to you the right that you're giving up by entering this plea?
Yes, ma'am.
Did anyone force you, threaten you, or coerce you to enter this plea today?
No, ma'am.
Are you under the influence of any medication that might affect your ability to understand what's happening here today?
No, ma'am.
Do you understand that if you're not a U.S. citizen, entering this plea may subject you to deportation?
Yes, ma'am. I understand.
How do you wish to plead today?
I put no contest to the charges.
All right, and do you also understand that if you've been previously convicted of a sexually motivated offense, entry of this plea might subject you to civil commitment?
Yes, ma'am.
All right. This time I accept your plea of no contest. I find the sentence plea freely and voluntarily after having the opportunity to review this plea form with your attorney with whom you are satisfied. I'm sentenced you as follows. I'm going to adjudicate you guilty of disorderly conduct. I'm going to sentence you to 2 days in the Orange County Jail with credit for time served for the 2 days that you already spent. I'm going to order that you not return to the scene. Your financial obligation, you'll have 365 days to pay, okay?
Okay, thank you, ma'am.
All right, good luck to you. Ta-da, we're done. Yay. Happy Mother's Day to every mother here, or who has a mother. That's everybody. Ay, ay, ay. I almost thought we weren't gonna make it by 2 o'clock. I had my doubts.
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.